Houston, Texas. I'm a partner in Reddy Newman PC. Our law office has been established on April 1st of 1997. We do exclusively business immigration. Today I have with me, along with me, Emily Newman, my business partner.
Hi, thanks for joining. My name is Emily Newman. I'm a partner with Reddy and Newman PC as well. And I'm also the writer behind the blog immigrationgirl.com, where I share practical tips from the desk of an immigration attorney. Today we're here to talk about the August 9th USCIS memo on unlawful presence for F-1 students.
Yes, this memo has created a lot of chaos in the immigration community, particularly for the student visa people. This memo was published in May of 2018. It is becoming effective today, which is August 9th of 2018. They have given an option for people to comment until June 11th of 2018, but the USCIS has not said anything about what they're going to do with the comments and how they're going to act with those comments. But this memo is going into effect today, which is August 9th of 2018. We're going to discuss the options for the students who might be affected by this memo. Emily, can you explain how this memo came into picture? What difference in general it will make before the memo and after the memo? What is the difference that the students will face?
Sure. So this is related to one of President Trump's executive orders related to national security. So the memo supposedly is based on some data that was put together about the number of F-1 students who overstay their visas and what options USCIS and Homeland Security have to act on those people that have overstayed. So based on what they consider to be a higher rate of overstay, they determined that they wanted to change the policy on what is unlawful presence, when does it begin, how do you accrue it, specifically for F-1 students. Now the reason why they're pointing out F-1 students is because normally, in order to overstay, you have to overstay the date ending of your I-94 card. So typically, for many other types of visa categories, when you're entering the country, you're going to receive an I-94 card that tells you exactly what date you need to exit the country by. For F-1 students, there is no date. It says duration of status, meaning that as long as you are attending your classes, maintaining your status, keeping a valid I-20, keeping up with your SEVIS record, then you're in status until your program ends, and then you have your OPT time. So your end date keeps extending based on your continued status in F-1. So there is no actual date by which someone can say you're officially an overstay. Because of that, now this new memo is giving us an actual end date, but on top of that, it's giving us a retroactive end date. So let me go back to what things were before this memo came out. So in the past, in order for an F-1 student to be considered as an overstay, there had to be a determination by USCIS or by an immigration judge that the student has violated status or is no longer in F-1 status. Once that determination is made, from that determination date going forward, the person is out of status and unlawful presence accrues from that date only going forward. Now, how does this memo change that? Now we're looking at not only from the date of the determination, are you unlawfully present, but going backwards to the date that the violation began, unless the violation occurred before August 9th. So it's very confusing, but basically, if you have not had a determination that a violation occurred, then if, say, tomorrow that determination comes, then they're going to say that from August 9th going forward, you're unlawfully present, even though you weren't told until August 10th. Did I explain it?
Yes,
right?
You did. It's a bit tough to explain it, but in essence what it is that if the person who is in United States has violated the status previously, since the day the USCIS makes the decision, from that day onwards, the undocumented stay would have been counted. But this memo contradicts the policy that USCIS has been having from past 25 years, and then says that it goes back to the day that the person violated the status. Now, how does this play into the student visa people, and how is it going to affect their unlawful stay? Here is the issue there. If a person is unlawfully present in this country for 180 days, there is a 3-year bar that they cannot enter back into the United States. They need to apply for the waiver before they can apply for any visa or any status. Now, if that undocumented stay goes to 365 days, then there is a 10-year bar for them to enter into the United States. So that's a major issue that is going to pop up with this thing. Since previously, when we used to get the denials for the change of status, that because the person has worked on a CPT, which probably may not be properly authorized, we used to get the change of status denied. So the persons used to exit and go to India to get the stamping, or whichever country they belong to, and then get the stamping and come back. But if that happens now, going forward, they will count the undocumented stay from August 9th. So from February 4th onwards, that's a count that I did it. 180 days, February 4th. February 5th is the deadline. From that time onwards, if the USCIS denies, and the student might have violated the status somewhere on the CPT or maybe on the STEM extension, he worked at a third-party site, which the USCIS might consider to be not working properly, there may be big problem for the students coming forward. So they need to be very watchful about the February 4th right now for those applications that are pending. So it's 180 days, 3 years bar, 365 days, 1 year bar. So this law retroactively is applying, so that's not a good thing for a lot of students. Emily, how many times have you seen where the person has been working on CPT? Did you see any of them getting denied because the USCIS considers that they did not work properly on a CPT? In those scenarios, what did we do before?
Right, we did see that. Over the last 2 years, we saw many requests for evidence on the change of status from F-1 to H-1, where USCIS was asking, how did you maintain status when you were doing this CPT program? There are 2 issues that can come up with CPT. The first issue is for those that start CPT immediately upon starting their grad school program. The general rule is that you have to be in grad school for 1 year before you're eligible for CPT. Now, there are many people who are getting CPT before the 1 year mark. They call it this day 1 CPT, based on an exception to that rule that says that if the program requires immediate participation in CPT, then you can get it before the 1 year mark. So we were seeing lots of requests for evidence asking us to prove that the program actually required the CPT from before 1 year. But the other issue related to CPT is for those that are doing a second degree at the same level. For example, you finished your master's degree, you used your OPT time, you used your STEM OPT time. During all of that, you were not successful in the H-1B lottery. So people are choosing to go back to school, but rather than going up a degree level to a PhD program, they're doing another master's degree at a different school. And in that master's degree, they're getting this day 1 CPT. Now the problem with that is that the regulation states that once you've used up 12 months of practical training, you're not authorized for additional practical training until you go up a degree level. So if you're going for the same master's level, you're not supposed to get more practical training. Now, up until 2 years ago, everyone was in agreement that that was talking about optional practical training, meaning that if you used up your OPT after your first master's, you shouldn't get OPT after your second master's. Now, because the actual regulation doesn't really specify between OPT or CPT, it just says practical training, USCIS is taking the stance that any practical training should not be allowed if you've already used up 12 months and now you're at the same degree level.
So not more than 1 year is allowed.
Right. So for those that have used that OPT or CPT after the OPT and they're at the same degree level, we were seeing requests for evidence on the H-1, and honestly, we were not successful in getting any of the change of status approved. The H-1B petitions were being approved, but the change of status was denied in every case based on that interpretation. And the individual would then depart the country, apply for a new visa stamp, and come in. Now, at the time of those denials in prior years, that meant from the date of the denial going forward, the person was out of status, and unlawful presence accrued from that date. So they had up to 180 days before any of the bars kicked in. Now, what's the difference with this new memo? How does that work if someone's in that situation now?
If someone in that situation is there, if they get the determination after February 5th, Emily, they will have to apply for the waiver of the 3-year bar that they have. And if it's determined in August of 2019, because a lot of these students who are working right now, at a later time, they're going to file application for change of status, and the determination might be made in August of 2019, to the August 9th of 2019, then the unlawful presence will be 365 days. There will be a 10-year bar that they cannot come into the United States. So for all those people who are contemplating or who are on the CPT, this memo might be a big blow for you. You might have to consider to take any action so that you can correct yourself on that. Emily, one of the things that comes up is that if suppose that we spoke about 180 days, we spoke about 365 days. Now, what if the person have done some violation before, and now he corrects himself and he is not in the violation? Will the 180 days start counting from August 9th because he previously violated, or will it toll the things?
Yeah, so I think that a lot of people might be under the misimpression that by stopping a violation, it cures a past violation. And in fact, that's not the case. So once you've violated your status, there's no going back. There's really no cure for that, even if you're now in compliance. The only real way to cure a status violation is to exit the country and come back in to regain your status. So if you've never exited the country, just because you're in compliance today doesn't cure the fact that you possibly weren't in compliance before. Now remember that with this memo, it's not just that unlawful presence automatically kicks in for everybody from August 9th who might be in violation. It still requires a determination by
the USCIS or the judge.
Yeah. So for those that have a H-1B pending right now and who are facing an RFE related to either their CPT or maybe STEM OPT working at a third-party site, if they were to respond to that request for evidence and get the change of status denied, what would happen if that denial occurred before February 5th?
If the denial occurred before February 5th, and I would rather caution February 4th, and they leave the country at this point of time, they can still apply for the H-1B stamping in India. But if the denial occurs after February 5th, and they determine that the person has violated the status B before August 9th, they already accumulated the 180 days, so there is a 3-year bar for them. Then they have to apply for a waiver, which takes a hell lot of time, and it's not that easy to get the waiver. They're in trouble.
Yeah, so those that have a pending case right now that are facing this issue, if you're choosing to respond to the request for evidence and argue that you did maintain your status, you may want to consider upgrading to premium processing as soon as it becomes available, so that you'll get the decision before the 180-day kicks in.
Which is February 4th. Or February 5th.
One other option for those that are facing this type of request for evidence, if you don't want to take the risk of being found unlawfully present, you could change your request from a change of status request to now you want to consular process your H-1B. In that situation, you're avoiding responding to the request for evidence on the issues related to your status. The petition itself can still be approved, and there should be no determination regarding your status because now it's not relevant.
Hopefully so.
Hopefully that's the
Emily,
plan.
for those, you're advising for the people who have applied for the H-1B, but what about the people who are in the CPT program right now that have taken the CPT after completing their degrees, and they're doing the double master's or double bachelor's degree now? What will happen to these people if the USCIS at a later date, maybe next year quota, they determines that they're out of status?
Right. So
in light of this memo.
Yeah. So say you're currently on CPT and you're planning on filing your H-1B in April 2019, and you file your petition requesting a change of status and it's selected in the lottery. You may very well receive a request for evidence asking you to prove that you actually maintained your F-1 status. If USCIS determines that that CPT was unauthorized, they may then determine that it was a violation of status and deny your change of status request sometime next year. At the time of that denial, they will determine that unlawful presence began the day you began the CPT or August 9th, whichever is later. So from August 9th to the date of that denial, even though you had no idea, USCIS is going to say you've been unlawfully present that whole time, assuming that that is more than 180 days, which is likely since you're not filing your petition until April. It's possibly even after 1 year, if
So
you
it's a
don't get the
10-year
result
bar.
until August,
Yikes.
you're subjecting yourself to a 10-year bar. So you may want to, or you should discuss this issue with your attorney before filing your H-1B in April and consider requesting consular processing of your H-1B rather than the change of status.
Emily, as we noticed that in January of 2018, the USCIS has quietly updated the website indicating that the individuals who are on the STEM extension, which is given after the 12 months OPT, and if they have a STEM degree, they could work for an E-verified company for a period of 24 months. They quietly updated the website saying that these STEM extension people cannot work at third-party site location. Though in the Department of Homeland Security, Immigration Customs Enforcement in 2016, clearly in their website mentioned that they could work at the third-party site. Now, could the USCIS right now, in light of this memo, if they determine these students who are working at the third-party site location, could this memo cause problems? And if so, at what time the problems are going to be, and what can they do to avoid these 3-year bar or 10-year bar?
Yeah, absolutely. I mean, what they're saying in these requests for evidence is if you're working at a third-party site on your STEM OPT, according to the USCIS guidance, that's a violation. According to USCIS, a violation therefore means that you're not maintaining status, and from the date of the determination of that violation, unlawful presence will kick in going backwards to August 9th. So if you're currently working at a third-party site and you have a request for evidence that's asking about maintenance of status, you could very well be opening yourself up to a finding of unlawful presence from August 9th. So for that reason, you may want to consider changing to consular processing or upgrading your application to premium processing when it becomes available, so that even if you get that determination that it was a violation of status and unlawful presence began from August 9th, you're not crossing 180 days before you get that decision. One question that came up was, for someone who currently is in day 1 CPT, they filed an H-1B, they have an RFE, but the RFE is only about specialty occupation. Should they be concerned at this point? Should they be taking any additional action?
There is nothing additional action they could be taking at this point of time. I would request still them to do the premium processing when the premium processing will come, because even if there is any problem that occurs at a later period of time, the undocumented stay period will still be from August 9th onwards. If they stay under the 180 days, they would be in a very good shape. If they exit the country before August 9th of 2000, exit the country before February 5th of 2018, there might be some creative ways to not go to some country and get the stamp and come back. They can actually go to Mexico and come back, maybe, I don't know, that might cure the whole issue. You may want to discuss with your lawyer on that thing. Even though RFE did not address it, I would be a little bit cautious in light of this memo. Particularly, I might want to take some action of exiting the country before February 4th of 2009, because at a later date something pops up, we can save that person because he exited and entered back into the United States.
What about withdrawing the H-1B? Do you think that's necessary at this point?
I don't think so. That's a good point, because that's not curing anything what you have already done. It's probably putting you into more trouble. I wouldn't withdraw the H-1B under any conditions just because of this issue at this point of time. Probably the next year's quota, I might want to consider that, but this year's quota, I will not consider withdrawing the H-1Bs at this point.
All right, now what do you think? So we talked a little bit about the fact that this memo says it takes effect August 9th,
right,
yet they requested public comment.
Right.
So should we wait for a final guidance to come out, or is this final? Why did they ask for all the public comments if the guidance was already going to be finalized August 9th?
This is kind of very unusual, MA, that they published a memo asking for the public comments. It's not precedented. I have not seen that kind of things before. Of course, they do that for the regulations when they pass it. This is not a regulation. They just issued a memo asking for the comment. And I looked into very closely, will they, when the effective date would be, are they going to change the memo based on the comments? They never commented anything on their website or in the memo itself. That in the memo they said it's becoming effective on August 9th. In the website also they said it's effective on August 9th. You are able to comment up to June 11th of 2018. But they never said anything that they're going to consider the comments and probably issue another memo. They did not. So I'm positive that that they will implement this as of today, which is August 9th of 2018.
So yeah, unless we hear otherwise, at this point, this memo is in effect and should be taken very seriously at this point. One other question that I've been getting a lot on the blog Immigration Girl is, what exactly are the things that cause you to violate your F-1 status? There's really not a lot of guidance out there. There's nothing out there saying, don't do this, don't do that, don't do that. So what are some of the most common ways people could violate their F-1 status?
Well, I can tell you one simple thing. In 2016, the new regulations for the STEM extension came out. When the regulations came out, Immigration and Customs Enforcement on their website of the Department of Homeland Security said it very clearly that the persons who are on the STEM extension can work at third-party location. Now, in January of 2018, just 2 years afterwards, they're telling, no, if you work at third-party location, you're violating the status. Isn't that a good example? You cannot tell how the USCIS is going to look into it. There are many different scenarios, the USCIS. What you consider legal today, what we tell you to legal today, might be turning out illegal tomorrow. So that's one example where I feel that the people need to be cautious. The other things is that when the CPT particularly, I mean, we have seen a lot of students who have not got the H-1B, they're getting the CPT. The purpose for the CPT seems to be that they're just wanting to do the job. That is one of the scenarios that a person could be violating the status, because I think so some of the CPTs are not in proper order. A couple of other things that I would be also cautious about is that when a person fails, or maybe he's unable to keep up the grades, that also will be considered to be a violation of the status. Emily, these are all the violation of the status for sure, maybe not, but is that by itself is going to kick the unlawful presence, or does the USCIS or DHS has to determine that the person they have to determine that this person is illegal?
Yeah, there's a difference between violation of status or being out of status and unlawful presence. So if you work without authorization, if you drop your course load below the required full-time courses, if you take too many online courses, all of those things may be violations of status that put you out of status. But the only time unlawful presence kicks in is when there's an actual determination by USCIS or an immigration judge that you have violated your status and are therefore unlawfully present. So just because there's a violation doesn't mean there's also unlawful presence. There does have to be an additional step of some kind of determination by USCIS before that actually takes effect.
Ayush has questions on the live, Emily. Is that he's asking a question. I'm on the CAP gap and I have an RFE and I'm working at a third party site. What do you advise me at this point of time?
Well, assuming that the RFE is related to the third party employment during the STEM OPT, you have a couple of options. Option number one would be to fight it, respond to it saying that the regulations say this is allowed. The ICE website says this is allowed. It's only the USCIS website that says it isn't, and they didn't provide any advanced warning of that change, so it should not be found to be a violation. That's option one. Option two would be to avoid the issue by changing your H-1B request to a consular processing instead of change of status. And in that situation, as soon as the issue with that situation is the cap gap. So you're only authorized for cap gap if you've requested a change of status. So if you are going to convert to consular processing, your cap gap ends. You should plan on exiting the U.S. until you get your H-1B approved, go for stamping, and come back. Now, if you do respond to the request for evidence and argue that your third-party employment was authorized and USCIS disagrees and denies the change of status, one thing I want to point out is you can't appeal a denial of a change of status. There's no appeal to the Administrative Appeals Office. You could potentially file a motion to reopen or a motion to reconsider, but the processing time of that takes so long, and it does not toll the unlawful presence while you're waiting for it. So you are likely going to have to exit the country anyways to avoid crossing that 180 days. But if you are choosing to respond to the RFE and make the argument, I really would recommend upgrading to premium processing.
And get the decision before February 4th.
Exactly.
February 4th.
So if you do get that denial, you need to leave before February 4th to ensure that you do not cross 180 days.
Arjun has a very good question. He had done some CPT in the second master's, and his H-1B is picked up in 2016. He's on H-1B right now. Do you think so it's going to be a problem for him, Emily?
If there was no travel after that CPT, yes, it could come up.
That's right.
So the only real way to cure a prior violation is to exit and come back in to regain your status. So if you did not travel in between, even if it happened 2 years ago, it very likely could come up again.
There are some creative ways of traveling. You might want to check with your lawyer. Instead of going to any other country, you could probably go to Mexico and Canada. And even if you don't have a visa stamping, you could come back. So you may want to discuss that option, because going back and getting stamping is another major issue that might pop up. So I would have him contact a lawyer on that.
Yeah. Vijay also has a good question. So say we convert to consular processing, we get the H-1B approved. Now I'm leaving and I'm going for my stamping. Is this issue going to come up at my stamping that I did day one CPT, or that I worked at a third-party site when I wasn't supposed to?
It could come up there, definitely. The State Department might come up. But at this point of time, if you exit before February 5th of 2019, you still fall under the less than 180 days. So there is no bar that you have accumulated. There is no, you're still eligible to apply for the visa, but it will be up to the discretion of the consular officer to grant or not grant the visa. He might consider that you worked on STEM OPT at third-party site. He might consider the CPT issue. But if you cross the 180 days, the consular officer does not have the authority to issue a visa. You have to go through the waiver of the 3-year bar, or in some cases 10-year bar. You need to apply for the waiver, get the grant of the waiver. Once the waiver is granted, then you have to make an application. It's a very lengthy and tedious process that you can avoid it if you leave it on February 5th.
Jaswal also has a good question. So he's currently in the initial 12-month OPT, getting ready to file the STEM extension. If he's working at a client location, can he file the STEM extension? What should he be doing right now?
I'm sorry, can you, I didn't hear it.
So if you're on your 12-month OPT right now, which right now it's
Right.
allowed to work at the third party
Yeah,
site,
good question.
no problem.
Yeah, so you're telling that on 12-month OPT, the persons can work at third-party site. Nowhere USCIS or ICE said that they cannot. They can work at third-party site.
Right. So now he's getting ready to file his STEM extension. Is he going to be approved for a STEM extension if he continues working at that third-party site?
There are some universities that are not issuing the 983, which is required. Endorsement of the I-20 is required, for which you have to file a 983 with the DSO. They're not endorsing the I-20s if the person is working at third-party site. And some of the universities are issuing the I-20s. We haven't seen any denials of the 765s, which is employment authorization, if the person is working at third-party site as of now. But you may want to be very careful. This August 9th memo might hit you at a later date. They might want to be very careful on that. I would be very cautious on this issue, because USCIS might strike you at any time on this. If you possibly can work at the employer site or the third-party site, I would do that under all conditions.
Now, if you are going to proceed and are going to work at the third-party site, when you are filling out the 983 form, you need to clearly explain that yes, you are working at the other site. So there's a section that asks for the employer information. There's a separate section that asks for the work site information. If you're working at a third-party site, don't try to cover it up. You need to give the accurate information, give your employer's address, but give the actual work site address so your DSO can see that you're working at a third-party site, and then it's their decision whether to issue the I-20 from that point. One other question that I'm getting quite a bit on the blog is, say that I'm working at a third-party site right now, or say I'm working on day one CPT right now. As of today, am I unlawfully present?
No, the USCIS have to determine that you are unlawful present. It's not, you cannot determine by yourself that you're unlawful. The USCIS has to determine. What this memo changed is that previously the unlawful stay started from the time the denial, or when the USCIS determines that you're unlawful, the unlawful stay started from there. But now this memo is going back to the day that you started violating. So it's going retroactively. That is a problem right now. Ayush has this question. How is this 180 days calculated? Is it determined by USCIS? Same question, I guess we answered, yeah.
Yeah, so that's the whole point of this memo, is before the 180 days would be calculated from the date of the denial. Now, the 180 days is calculated from the date of the violation. However, if the violation started before August 9th, then the 180 days is calculated from August 9th. If the violation occurred and started after August 9th, then the 180 days is calculated from the date the violation began. But again, this is only in the event where there's actually a determination, a decision from USCIS.
Nikhil has a question of the day, I would say. Can you please explain how the consular processing is different than the regular H-1B transfer? And in the light of the August 9th memo, I'm adding this one to the comment what Nikhil is. In light of the August 9th memo, when you're recommending people for the consular processing instead of change of status, how does it differentiate? What are the advantages and disadvantages of the consular processing?
Well, the difference between consular processing and a change of status is that consular processing requires you to exit the country and apply for a new visa stamp. A change of status means that while you're in the United States, your status will automatically convert from F-1 to H-1 on the day the H-1 approval takes effect, usually on October 1st. You never have to exit the country in order to make the H-1B active. Consular processing, you have to exit the country in order to make it active, and the only way to get back in the country is to go for H-1B stamping at the consulate. That's what consular processing means, is that you're going to process your visa at the consulate. So now you have to make the interview appointment, You have to fill out the DS-160 application form. And even though you got an H-1B approval from USCIS, the consulate does second guess everything in that approval. And they are going to ask questions about whether you've ever violated your status before. You have to answer those questions truthfully, so that the consular officer can then make a determination about whether you're eligible for the visa or not. Now, we've been talking about this 180 days in the 3-year bar. If you have unlawful presence, but it does not reach 180 days, and you exit the country and apply for a new visa stamp, that unlawful presence of less than 180 days by itself is not a reason to deny the visa stamp. It doesn't make you inadmissible. So just because you had some unlawful presence or a violation doesn't mean that your visa is going to be denied. Now, you do have to be honest and upfront about the situation so the consular officer can review the situation. But if you are honest and upfront about it, the violation by itself will not cause you to not get the visa.
One question Nani has this on the live, Emily, is I am on OPT extension working at third-party site. Am I violating the status?
I think it depends on who you ask.
Oh, well, let's say I ask the Department of Homeland Security and I ask the Immigration Customs Enforcement.
Yeah, if you ask ICE, according to their website, it's not a violation. If you're filing an H-1B, and that means you're asking USCIS, according to their website, it is a violation. That's the problem with this whole August 9th memo.
So what are you telling?
Nobody knows until USCIS makes a determination that it's a violation. Is it a violation? No one really knows. That's what's so frustrating, is some people might end up into a trap where they've been found to be unlawfully present for a violation that no one knew existed. So it is very unfair the way this website change occurred, how they're implementing it with no advance warning, with no guidance on what to do. We have no idea at this point. We are just experimenting and waiting to see how USCIS responds based on the arguments we make at this point.
At this point, it seems to be that the effective date is going to be February 4th of 2009. That's where the law will become effective, because from then onwards, if the USCIS determines that the person has violated his status, you might have good problems. In answering the question of Nikhil, Emily has stated that the consular processing, the pros and cons of consular processing, and also the change of status. One of the other thing, Emily, is that when the status issue comes up in the RFE, that the person is, the USCIS is challenging either the CPT or the STEM extension, that they have violated it by either working at third party or working in the CPT in an instance. So when you request the consular processing, is it automatic that the USCIS will not determine anything on the status, or will they still determine that the person is out of status and issue the H-1B without the I-94?
They shouldn't. They can do whatever they want, but when you're requesting the conversion from change of status to consular processing, it should be treated as if you initially filed the application in consular processing. If you look at the form instructions for the I-129, there's a section on maintenance of status that only applies if you're requesting a change of status or an extension of status. It tells you what documents to submit. So if you're requesting consular processing, that whole section becomes irrelevant. So there should theoretically never be a determination made that you violated your status.
And then when you said that if the USCIS does not determine, the unlawful status doesn't start accumulating.
Exactly.
Now that gives a creative solution for me going forward, maybe from February 5th onwards or next year quota onwards. Could we just file the case in the consular processing and avoid the complete status issue if we think so that our clients might be having some issues about the 100 CPT or STEM violations?
Yeah, I think that's very likely that that's what we'll be recommending next March and April for our quota filings. The difficulty is going to come in for those whose OPT is expiring between April and October. So normally if you do request the change of status, you get the cap gap extension of your OPT that extends your work authorization through September 30th. But if you're requesting consular processing, that means when your OPT ends, you must stop working, you enter the 60-day grace period, and then you have to exit to get the H-1B stamped and come back assuming that it's approved. So it's a little too early to predict how all of this is going to play out. But assuming things go like we're expecting them to, I do think consular processing and next year's quota may be a good option for people who have a potential
issue
violation.
Of the violation.
Yeah,
that might be. And then for those people whose H-1Bs are pending, I would recommend very strongly that you get the decision done before February 4th. And as Emily pointed out, you might want to discuss with your lawyer that if you want to convert your H-1B into consular processing, the other trouble that pops up is that if you convert into consular processing, if you do the change of status and you challenge the USCIS, you get the denial, then you have to stop working immediately.
Right.
And they have to go to the stamping, and which might take a month's time for them to make an appointment to go stamping, and the end client might not be willing to wait that much time. But if you actually choose to go for consular processing instead of challenging the USCIS, you can still continue working. I mean, there's nothing that says that you cannot continue working if you get the consular processing.
Yeah, if you have the
if the
STEM
USCIS
OPT
did
or
not
CPT.
determine that, and then you can go at your sweet time, not after February 4th. It's at your sweet time.
Right.
So the day to remember is before February 5th of 2019. When the IRA, this legislation which actually passed, became effective in October of 1996, Emily. What I did was that the effective date was April 1st. The 180 days effective date was actually April 1st of 1997. Reddy and Newman PC was formed originally as Law Office of Arbitrary on that day when this 180 days actually kicked off. Before April 1st of 1997, there was no 180 days and 365 days. There was no 3-year and 10-year bar. 3-year, 10-year bar became effective on April 1st of 1997. That's when Reddy and Newman PC, back in old days, used to be called as Law Office of Arbitrary, was formed. That's this time it's actually, since the effective date is actually February 5th is the effective date. I want all the people to be very careful if they fall into that criteria to take action well before, and going forward they might want to discuss if they want to file the consular processing instead of filing the regular processing.
Yeah, and one other thing to keep an eye on is this NTA memo. That memo came out a month or two ago. It was supposed to take effect immediately, but the service centers were given 30 days to come up with their procedures. So right now, because they didn't come up with their procedures on time, the NTA memo is on hold. That doesn't mean it's on hold forever. So that memo is likely to come into play at the same time we're seeing decisions on H-1B petitions up through August 9th and through February 4th. So as a reminder, when the NTA memo kicks in, that means that when a decision is made that you are denied for the status you've requested, so for example, you have a pending H-1B change of status from F-1 to H-1, and that change of status was denied, and it's found that it's denied because of a status violation, meaning that now the August 9th Unlawful Presence memo kicks in and says you've been unlawfully present from August 9th. On the date of that denial, USCIS, according to the NTA memo, is required to issue a notice to appear in removal proceedings. That means that if the NTA memo comes into play, we also have to worry about ending up in deportation. So it's not just a matter of not reaching the 180 days. We also have to keep an eye on whether this NTA memo is going to come into play, and if it does, is it possible that by making the argument and USCIS ultimately determining that there has been a status violation and therefore there is unlawful presence, now are you subjecting yourself to the possibility of ending up in deportation, which is definitely something you want to avoid.
Harsha's good question. Do we have to leave U.S. immediately if we convert the H-1B to consular processing?
That is a really good question.
Very good question.
So it depends. If you are maintaining your F-1 status, so for example, say you're on your OPT STEM extension and your OPT STEM does not expire until July of 2019. In that situation, no. When you convert to consular processing, your F-1 is still valid. You can continue working until your OPT expires. You have to leave by the time your OPT expires in July of 2019. Same thing if you're on CPT. As long as you're maintaining your F-1 status, attending your courses and working with the CPT, you can keep doing that the whole time your CPT is authorized, the whole time your courses are going on. You can continue that even if you convert to consular processing. The only case where it's different is the situation where you're currently on the cap gap, because cap gap, you're only eligible when you file a change of status. Now that you're requesting consular processing, your cap gap is no longer there, so you must leave in that situation.
If the one question that came out was that Vijay has this question is that if I go for the consular processing, I'm on CPT right now, can I actually, if I get the H-1B rejected in India, can I come back into United States on the CPT? I have he has the visa stamping valid still on the F-1. No, you cannot come back. Once the visa has been rejected, all other visas that you have in your passport are automatically invalid. You cannot come into the United States once the visa is rejected. You don't have an option of coming into the United States. You have to, if you want to come, you have to apply for an F-1 visa again, which I would doubt very sincerely they would give it to come back into the United States. Any other things that I'm missing, Emily?
One other question about consular processing. Do you have to only go to your home country, or what are the situations where you could maybe go to Canada or Mexico?
Well, you could go to Canada or Mexico, but however, in this particular scenario, when you have applied for the H-1B and you got the H-1B approval while you are in United States without the I-94, I strongly recommend them to go to the home consulate though. There are many issues here, Emily. One of the things is that if a person is not in documented stay for one single day, the only country that they can go is their home country. They cannot go to a third country to get the visa. When the I-94 is not been issued, it creates a lot of doubt, as you pointed out before, that why did this person got a H-1B without the I-94? It creates a doubt, and when you go to Mexico or Canada, you will have a hard time there because one requirement is that if there is a status violation, you should go to the home country. That one reason, extra reason you have it when you go to Canada and Mexico. I will try not to go to Canada and Mexico though I don't think so there is a ruling here, I would not take any chances in going to Canada or Mexico. Any other things? More questions coming up live. No, more questions. Do I have to go for stamping? If you have converted the H-1B processing because of the August 9th memo, a lot of lawyers might recommend you to convert your visa into into the consular processing. The H-1 is not valid unless you go to the stamping and you come back on the I-94. So just because you got a H-1B approval, that which does not have an I-94 will not allow you to work in United States. You are forced to go into your get the stamping and come back.
Pranav has a good question. He was actually on, had a master's a couple years ago, did the whole OPT thing, did a second master's with CPT, got selected in the H-1B lottery a few years ago, got approved for H-1B with the change of status. Does the August 9th memo apply to him since he's in H-1B status?
Yes, it does. It depends on if he has traveled outside the country and came back in.
Well, I would say the August 9th memo doesn't, because that memo specifically says it only applies to those currently in F-1 status.
Oh, okay.
So he's already in H-1 status. That being said, I think what you were going to say was that it could come up in the green card.
Right.
In the 485 application, because you always have to show you're maintaining status from the date of entry. So if you have not traveled after getting that H-1B, even though this August 9th memo might not apply to you, you still always have to prove that you've maintained your status from the date of entry. So this could come up during your adjustment of status. Now, if you have traveled, the adjustment of status only looks to the date of your last entry going forward to determine whether you've maintained your status.
Yeah, I would be consulting a lawyer to make sure that if you can make some travel arrangements and cure it if you have not traveled. That might be one of the things that I'll be worried about. One question that keeps on arising, Emily, is that how the students ask, how would the USCIS find out all these things? Can you give?
Well, keep in mind we have this new SEVP portal where DSOs are entering information, students are asked to enter information, their address updates, their employer information updates. So yes, USCIS does have access to some of that. Now we don't know how much, because typically it's ICE that is looking at the SEVIS system. But it's very likely that the information that they need that might raise some questions is already in the SEVP system based on information entered by the student and by the DSO about their employment or about the courses they're taking. So yes, everything is being monitored through that SEVP system now.
We have now smart systems that calculate when the person did violate it, when the person did not violate. There are a lot of artificial intelligence that the USCIS is adapting to look into the things, though. Back in olden days, when I started practicing immigration law in 1995, Emily, everything was in the paper. It was very tough for the file to come in there. But when I go to the USCIS interviews right now, the officer has access to the application, the visa application that he filed when he entered into the United States. From that time onwards, all the way to the citizenship time, when I go for citizenship interviews, I see the entire file in there. From the day he applied to right now, the whole history is there. Now the CPT, when it has been granted, it is granted in the SEVIS system, which is not going anywhere, the record is there. And when the person is working at a third-party location, that's also registered because you have put your address in the SEVIS system, and also in the 983 has been updated and it has been given to the DSO who inputs that information into the SEVIS system. So all that information is there. There are some cases that they are denaturalizing, going back to a long time ago. But with regards to the OPT and STEM extension, I think so. I want to be very careful because if later on when they go to the green card, I don't want this memo to be affecting their green card application.
Yeah, and also from pay stubs. I mean, your address is on your pay stubs, your employer address is available, and they can easily see if your address is 1,000 miles away from your employer's address. They may question, are you working at a third-party site? So it's very easy for USCIS to find the information they need to make these kind of determinations. We had a question about someone currently finishing up their first master's and finished up their OPT. Now they're thinking of going back to school for another master's and an MBA this time around. Is going back to school for the second master's by itself a problem?
You missed out the full question, Emma.
I know. I just wanted to start with getting a second master's isn't necessarily a problem, but should you get that second master's and do the CPT, is that going to be a problem?
That's a problem.
That's
because
the whole point.
The reason seems to be that the person going into the MBA seems to be to get the CPT, not to do the college. And the CPT that's been issued immediately when you join the college, I don't think so that's appropriate. A lot of law schools in United States, including the law school that I and Emily has went, they don't even allow the students who are in the first year of the law school to work anywhere. They want them to focus on the study. Only after the first year of their law school, they're allowed to work in any offices or any places. That's how Emily started working. She didn't work until she completed her 1 year of law school. That's when she started working with Reddy and Newman PC. Well, back in old days, it was Law Office of Harvard Reddy. So even US citizens have the restriction. I don't know how these universities are issuing the day one CPTs. I wonder them.
Yeah. So let's just to recap, because I'm getting another question on day one CPT. Do we recommend, if you've already completed a master's, going back to school for another master's and getting the CPT as a way to keep on working?
No, that is a suicide. I don't think so. You should be getting a CPT at all on the second master's degree.
Now, can you do CPT in your last semester? I think that depends on if this program is a second degree at your same level. Now, if, say, you're here on your first master's, you're studying for 2 years, and now in your last semester you're getting CPT. There's absolutely no problem with that. Our problem is after you've done a master's, you've done all of your OPT, now you're going to school again for another master's and you're doing immediate CPT. That's the problem. It's the immediate CPT at the same degree level. Why are you going back to school? Is it really to study, or is it just to be able to continue working?
Amit has this good question, Emily. His H-1B has expired, his H-1B expired in May of 2018, and he's filed an extension. When his extension gets denied, does the date go backward? Is this memo is applicable to him? He's on H-1B, filed an extension.
He's on H-1B.
No, this memo is not applicable for you. If you get a rejection of the extension, the unlawful presence for you will be from the day of the denial, not the day your I-94 expired, unless the application is a frivolous application which has no basis at all. Then they might go back to the May of 2018, which I believe very strongly your application should be a very genuine application. Maybe because of the specialty occupation or some other reasons it might be denial. So your unlawful presence will be counting from the day it's been denied, not it doesn't go back, at least now.
So some people are asking about what are the restrictions on CPT and OPT. So number one is if you are in a graduate school program, you're not supposed to take CPT within your first year unless your particular program requires immediate participation in the CPT. Number two, if you use 12 full months of CPT, you lose your chance at OPT after you graduate. Number three, if you graduate, use all of your OPT time and then go back to school for another degree at the same level. According to current interpretation, you should not be taking CPT at that time either. Those are the main restrictions on CPT versus OPT right now.
Any things that are not covered, Emily? We're only asked, Reddy and Newman PC, we bring in every Tuesday live at 5 o'clock. We cover overall subjects, but we decided that we're going to cover each subject separately. This particular live show is only about the August 9th memo and the student issues that are linked with the August 9th memo, the CPT, the OPT, and the student violations. Now, other than the STEM extension, other than the CPT violations, there are also other restrictions that are there on the CPT, OPT, or STEM extension, that the person must be only working in the relevant field. So if a person is a mechanical engineer and he's working on a software engineering field, software side, he may be violating the student visa status. That might be, we might want to be very careful also on that. And also, Emily, will they go back previously for those people who worked on OPT in a not relevant field? If they worked in a mechanical engineer worked on
Yeah, I think if they're still in F-1 status, that's very possible. I mean, we saw those types of requests for evidence on the I-765 application for an OPT or for a STEM extension, asking how is this job relevant to your field of study. So I do think that that could come back later in another application.
Pramod, he's working at third party on a STEM extension, his RFE is not addressing, they did not ask the questions about the STEM extension working at third party location. Do you advise him to go for console processing at this time?
I don't think I would. I don't think they're going to deny the change of status without first asking about maintenance of status. So if it's not brought up in this RFE, there's a chance you could get a second RFE bringing it up. But if you don't, then I think you should be relatively safe. That being said, now what we talked about is that the only real way to cure a status violation is to travel. Now, if you do happen to get the H-1B change of status approved, you may want to consider at some point traveling and getting that H-1B stamped and coming back in so that you won't have a problem later on when you're filing your 485 for your green card.
For all good reasons, I want you to get the result before February 4th because that's absolutely necessary for you because one, as Emily has pointed out, you could always get a second RFE on that. In 2017, we have seen a lot of H-1Bs where we have received a second RFE once we answered the first RFE. So you could be getting the second RFE. I wouldn't take any chance. I would get the H-1B adjudicated early, Emily, because if by any chance he get the second RFE, then he could judge at that point of time whether he want to do the console processing. Now, one other thing you are advising, Emily, everybody to get the result before February 5th. The only way seems to be that for most of the people to do is by converting it to premium processing. Now, there is a rumor that says that premium processing has more tendencies to get the RFEs. Premium processing has more tendencies to denial. What is your take on it?
Yeah, in my opinion, those rumors are completely false. There should not be any difference between the way a regular processing petition is adjudicated and the way a premium processing petition is adjudicated other than the time frame. Now, I think that a lot of people that upgrade to premium and end up with a denial are upset that they got a denial after spending an extra $1,200, and maybe they're thinking that the premium is what caused the denial. But I can guarantee you the premium is not the reason for the denial. The premium is not the reason for the RFE. If you had waited 3 more months in regular processing, you would have gotten probably the same RFE, and you likely would have ended up with the same denial 2 months later in regular processing. The premium does not cause the RFE or the denial. It's the petition itself.
Anything else we have left over?
Other than that, I would just say, most importantly, we're here providing you general guidance on this memo and how it impacts you. But please, for your specific situation, you absolutely need to talk to your attorney before you take any actions, before you're responding to a request for evidence. Make sure to speak with your attorney on what the best options are for you before you travel. Talk to your attorney. If you need specific advice on your situation, our firm is always available. We have consultations where you can speak with Rahul or myself or any one of our other attorneys just by going to rnlawgroup.com. Select consultation, and you'll be able to get all of the details there. We also have a daily conference call where you can join in and ask your questions for free. So all of that's on our website at rnlawgroup.com. You can always visit immigrationgirl.com for the latest information and ask your questions there as well. Follow us on Twitter at rnlawgroup or at immigrationgirl, and we're on Facebook too. So thanks for joining us, and keep your questions coming.
Thank you guys for coming in.